three stakeholders or sources of power for disclosure. And when he follows through the history of disclosure, he identifies the judge, the prosecutor, and I later add defense counsel. Now, when he deals with South African jurisprudence, as we move from 1948 onwards to 1993, I guess, he also identifies that as the security state developed to its height, it specifically hobbled or spoilt the prospects of defense counsel getting disclosure by either legislating it away or putting it in control of the Minister of Justice, who delegated his refusal to disclose information to the various then attorneys general. Then in 1994, what happened was that whole process was turned on its head, and it was set aside. The previous methodology of suppressing information and preventing defense counsel from getting that information was swapped entirely, 100% turnaround, where disclosure in terms of the interim and final constitutions were made available. Now, in addition, as I interpret it, the source of ensuring early disclosure and proper disclosure also now depends on defense counsel, because defense counsel needs to know the law. Defense counsel needs to know that there should be disclosure. And the concomitant legal devices that the security state used, like reverse onuses and so on and so forth, and a really retrogressive interpretation of the 174 discharge, have now been turned on their head. But they have to be empowered by proper disclosure of the state's case. Now, this is not directed at the prosecution authorities as if, open inverted commas, they are the enemy, close inverted commas, because when there is this disclosure, they are forced to investigate matters properly by virtue of the fact that they anticipate that there will be disclosure. So, insofar as they are concerned, their conviction rate, the quickness of the trial, there will be no unreasonable delays and so on and so forth. And if they do their job properly, for example, Section 105A pleas will be easier to get, and the whole accusatorial process will be made far more efficient. So if people pay attention to the provisions of disclosure, there will be an understanding from the state that their success rate will be higher because they investigate matters properly. So there are very important reasons why there should be full disclosure. Now, when you deal with the presiding officer, he has a mandate to ensure, a constitutional mandate to ensure that a trial is fair. So in order to do that, in order for the presiding officer's decisions not to be arbitrary, but rather rational, reasonable, and reasoned, they have to be active in putting pressure on the state so that the state makes early disclosure. One example would be Section 6014 of the Criminal Procedure Act, which basically gives the prosecutor a discretion in Schedule 5 and Schedule 6 instances, like serious offenses, not to make disclosure. Now, I personally am of a view that the constitutionality of that provision should be attacked, and that there should be disclosure in every bail application. However, that's not the law at the moment. But this puts pressure on the presiding officer, because if the defense indicate from what they already know that there is no prima facie case, the onus of proof in Chabalala doesn't change. The onus of proof is on the state to declare why disclosure should not be granted. And even if the Act says the prosecutor is exercising a discretion, it is an administrative law discretion, and accordingly the prosecutor should make that decision on a rational, reasonable basis with reasons, and it cannot be arbitrary. So in those circumstances, the presiding officer should place the state representatives on terms. There are provisions of Section 60 which allow this. There is the law about judicial peak, and there is basically what this breaks down to is a presiding officer in a Schedule 5 or 6 bail application where the defense attacked the prima facie, whether the state has a good case, which is dealt with in Section 60 of the Criminal Procedure Act, is one of the issues the court must look at. In those circumstances, the state can call the investigation officer. Now, insofar as that is concerned, obviously defense counsel will be able to cross-examine the investigation officer, and obviously in the process of doing so, if at that stage the docket is not provided to the defense, the cross-examination can extract from the investigation officer what is actually in the A, B, and C sections of the docket. So one would then ask, why not just disclose it? Now, there are very good policy decisions for why there should be full disclosure. Accountable democratic government explains itself, and disclosure protects a number of constitutional rights of the accused. Now, obviously, and you will hear presiding officers tell you this when you bring this application for disclosure, fairness, and the key judgment comes to mind, fairness is not only fairness to the accused, it's fairness to the state. Now, I've already elucidated that if the state makes rational, reasonable, and reasoned decisions which are not arbitrary, its success rate will improve drastically. So the asking for disclosure will raise that prospect, and the constitutional weight of looking at the interests of the state and the interests of the accused will be satisfied by full disclosure, because the state will have to do their job properly, and the right of the state, therefore, to prosecute crime will be satisfied. Now, obviously, when you look at policy, it's very, very instructive for you to look at what the security state was about. We are looking for open justice. The security state was after closed justice. And if you look at the Internal Security Act, you will see that almost every provision of sections 34 and 35 of the Constitution were gutted by the Internal Security Act. So the minister and his appointed directors of security legislation decided what would be disclosed, when it would be disclosed, and what could be hidden. And generally, they decided to hide it. That paralyzed the oversight, judicial oversight of the presiding officer at the time. So principles like audi artem partem were just thrown out of the window. in fact, the accused himself was not even allowed his or her own statement, and could only obviously get that information if where parts or the whole statement were disclosed in court. The accused in those circumstances had to deal with many reverse onuses, which are now, except for notable exceptions, unconstitutional. And then, of course, the 174 discharge law was decided by cases such as Kritzinger and Schupping, where it became practically worthless to apply a 174 discharge because the requirements of satisfaction of those cases made it a racing certainty that a discharge would not be granted. So when there was not disclosure, think about it now. You were paralyzed in leading evidence of the warning statement of the accused. The defense counsel was paralyzed about admissions, confessions, pointings out, trials within trials, evidence of a child witness, to mention a few. All of these issues, the cross-examination of those state witnesses, were completely, the defense counsel was completely hobbled in presenting their case because they were actually boxing in the dark. Now, full disclosure now reverses that entire process, because in those watershed moments in a criminal trial, you have full disclosure, for example, of how a confession was taken. Now, it's very important what full disclosure means when you look at, for example, a confession. There are standing orders that relate to how a statement is made, the accuracy of how a statement is made. And some of you might be aware, for example, of the Brainders case, where a statement only has to be a brief summary, and we must remember the language barriers in South Africa, so the statement doesn't really have to be accurate. And if there are contradictions, well, the low standard we should expect of South African police statements disallows the defense from taking advantage of those contradictions. However, if defense counsel knew that the standing orders require exactly the opposite, they require detailed statements where issues of admissibility are dealt with, where hearsay evidence is supposed to be relied on as seldomly as possible, and where hearsay evidence is relied upon, the necessary steps for corroboration must be in the statement. Now, if that was known, when you're dealing with a confession, for example, you have a great deal to attack the admissibility of the confession on. Just to give you another example, a policeman must have a pocketbook. The judge's rules are in the first 13 pages in all the languages in South Africa in the pocketbook. I would suggest to you that the pocketbook does not actively reflect the full detail of the judge's rules, but that's a very good start. The pocketbook standing order requires a South African policeman to record in his pocketbook how he warned the accused according to judge's rules, and in other words, exactly what he said, exactly what the answers were, and the accused is required to sign in the pocketbook that that is what transpired. Now, when you look at the admissibility of a confession in those circumstances, my experience is that the testimony of a South African policeman in court usually materially contradicts what's in his pocketbook. And that obviously would affect the admissibility of a confession, a pointing out, and so on and so forth. In a case I have recently, the admissibility of cell phone evidence and the fact that the relevant acts were not complied with was adequately indicated by the contents of the pocketbook. And the state witness concerned took the risk of just getting unlawful evidence and trying to run roughshod over the accused's rights when the matter was presented in court. And the way that it was proved that that this particular police person was doing that was by getting access to the police docket. Now, when you look at one of the other important considerations of getting full disclosure of the police docket, you must understand that, and we have had this crisis in South Africa for a very long time, the public's faith in the criminal system is raised by proper investigation. So at the bottom of all of this is always investigations will improve if there's full disclosure. Therefore, the public will buy into supporting the judicial system insofar as criminal law is concerned. Now, American jurisprudence has seen similar problems, and they have gone through a process where there was not disclosure, and there now is disclosure. And the type of difficulties we're having in South Africa, they have had in the American system. And what they've gravitated towards now is disclosure by the state of everything that they have in their investigation, which now leads me to deal with the issue of what should be disclosed. Now, South African police docket consists of the A, B, and C sections of the docket. If the Chabalala decision is read, it will be seen that most of the judgment is directed at the A section of the docket. Now, that case has complications because it deals with the A section of the docket. It enunciates by the way of obiter that the same principles would apply to the B and C sections of the docket, but it basically leaves the development of the law insofar as that is concerned to the Supreme Court of Appeal and the local and provincial divisions. Now, if you read the order in Chabalala, it talks about the docket must be disclosed. And in his Lordship, Mr. Justice Clutie's definition of the docket in the Transvaal Provincial Division judgment on Chabalala, he describes the docket as the A, B, and C sections. In terms of the prosecutorial regulations, they also describe the docket as the A, B, and C sections. I've already addressed you a moment ago on the issue of the pocketbook. Now, the pocketbook is not in the docket. So when I argue and I refer to what disclosure should be, I use the term state brief because during the security state era, the state brief was described as widely as possible because if it was secret and you put the most information within its definition, if it covered the most information, it's like a big umbrella. If it covers everything, nothing has to be disclosed. So in the definitions of the docket, it was described as including practically everything. For example, in the security legislation, it literally was stated to be everything in the state's hands when it in the process of it preparing for trial. So for example, the way I read it, the police docket would be, the pocketbook would be included in that. And the more recent authority is that the state cannot redefine itself in order to limit the disclosure of the docket. Now, I appeared in the Kerr-Phillips matter, and I have to concede, although I won the Kerr-Phillips matter in the end, so that preserves my 2008 statistics that we referred to earlier. Insofar as Kerr-Phillips was concerned, I had difficulty with that. And his lordship in that matter pummeled me, basically. But one of the good things that he said in that judgment was that you could bring the application more than once. It's an interrogatory application. So if you don't win the first time, you can apply again. Now with that ammunition in my barrel, I did bring the application again before the magistrate who was presiding in that matter. I got full disclosure, and in the end, before the end of the state's case, the state closed its case, and I got a 174 discharge, primarily on what was in the docket. But the other area that I functioned in, or the other area that I asked disclosure for, was the teddy bear clinic information on the assessment of the ability of children to testify. Now what actually happened, and why that case, the state's case was closed, is that the state representatives in that matter determined or realized that if I had a successful judgment in that matter, in all their rape cases and child molestation cases and so on, they would face the prospect that the Teddy Bear Clinic or the NGOs like the Teddy Bear Clinic would have to disclose the contents of their consultations with a complainant who's underage and their psychometric testing of the complainant and so on and so forth, and would leave the opportunity open to the defense to actually get that information so that they could brief their experts with it. One of the reasons why the state decided to close their case is they didn't want a reported judgment on exactly that point. Now subsequently in my litigation, I have brought that application again, and recently I'm involved in a matter before a regional court where I'm repeating that procedure, and thus far the magistrate has permitted my expert to interact, also applying the Chabalala section on witness evidence, that the defense witnesses or the defense may consult with state witnesses. The magistrate has agreed that the two psychologists involved in that matter and the social worker exchange psychometric testing and consultation data with my expert so that they might bring out a joint report. Now, I am confident in the matter that I was talking about recently, that the result will be that my client will be found not to be a competent witness to testify, and therefore that the matter should be withdrawn. Now, I left out the essential fact that the two state witnesses which my expert will speak to has already, the two state witnesses have found that my client is not a competent witness. But what you're hearing about all of this, and why I'm telling you this anecdotal evidence, is because the process of acquiring this knowledge about the state's case was obtained by asking for full disclosure of the state docket. And while the full disclosure of the docket has not yet been given, from what I already know about the A section of the docket, I'm reasonably confident that the matter will simply be withdrawn. This is after, of course, my client had spent many days in custody. Now, getting back to why you heard all of this, it is very important that it be understood that there should be a wide definition of the information that the state should disclose. I call it the state brief because the way I came across that term is the state brief prior to 1994 was not disclosed. So the state representatives argued for that definition to be as broad as possible, to include everything the state prepared for trial, so that the defense could not have it. Now, as a result of the constitution the Constitution and the Constitutional Court judgments. The principle underlying disclosure or not has changed. In other words, the Chabalala decision turned the Steyn decision, which was the security state decision, on its head. They now say that the state brief should be disclosed, not hidden. But at the same time, they are now, the definition, the wide definition of the state brief has not changed. So in my respectful submission, everything the state has should still be disclosed. Now, I have already dealt with the principles why this should be so. By saying the state's case will be more efficient, and the defense can inform the presiding officer of any misdirections committed by the state, so that, for example, the accused might be granted bail sooner, a confession might be ruled inadmissible, a 174 discharge granted, a trial within a trial lost by the state, and so on and so on. The list becomes endless. But what this will also do is will force the state only to bring cases that it can win to trial, and not just to willy-nilly enroll everything, which I believe is the practice up until now. Now, when you apply for the docket, the full docket, you must, in my humble submission, you must realize that you are on very good grounds in any matter. Because when an accused is arrested, many constitutional rights are restricted. Many of his or her constitutional rights are restricted. These would be the rights to dignity, the rights to freedom, the rights to bodily integrity, the right to have sexual relationships, the nature of which you choose yourself. There are many. And the point of the matter is, when you, in addition, look at the absolutely terrible conditions that exist in our South African prisons, when you raise these constitutional rights that need protection, in my humble submission, if the courts are forced to recognize that, and the jurisdictional facts are placed before court by the full disclosure of the police docket, then there will be far less people in South African prison who shouldn't be there. Now, when you look at the standing orders themselves and the contents of the docket, you should be mindful of the following. There are standing orders for arrest. There are standing orders for bail. There are standing orders for a crime register. There are standing orders for arrest with a warrant and arrest without a warrant. There are standing orders on how the charge office commander must regulate and control dockets that are coming into him immediately. Let's deal with that very quickly. An accused should be arrested and brought to court within 48 hours. And obviously, I'm sure all of you who are listening have the additional knowledge that if you arrest on a Friday, you can bring the accused to a court on a Monday or a Tuesday. Now, think about a bail application. There are standing orders that provide for all these events, and when one looks at the standing orders, and when you, and if you ever need them, I'm sure, well, my email address and my telephone numbers will be provided for you. I have them in hard copy and electronically, and they can be sent to you. Now, let's look at how you're going to use them. All right. you're going to, first and foremost, when an accused is brought to court, you're going to disclose to the South African police immediately that you have the standing orders. So you know about the 48-hour rule, you know about the weekend rule, and you also know, and you're going to convey that information to them, you also know about what they should be doing. I'll give you an example. One of the games that are played in a criminal court is that the prosecution need time because they arrest first and investigate later. So very often you will find a prosecutor standing up and asking for postponements for the purpose of verification of the accused's address. Did you know that in the first 10 hours of the 48 hours, the Criminal Procedure Act and the standing orders say that address should be verified. Now, normally, you get about 2 to 3 weeks postponements pending a bail application so that the address of the accused can be verified. Leaving aside, of course, that if he's arrested at his home, they know his address. So, did you know that? Did you know that there is a standing order on how the arrest of children should be handled? Did you know that there's a standing order that deals with an ill client? In other words, now you might say to me, well, it's dealt with in the case authority. So think about having to research the case authority as opposed to having the state document, which is drafted premised on the case authority, which the state knows because it's their document. And therefore all the principles are common to the parties. So instead of trying to persuade a magistrate over 2 to 3 days what the law is, you just hand in the standing order, and the standing order has the state version of what the law is. So for example, if your client was extremely ill, there is a procedure for that. You are the South African police are bound, when a client is very ill, to take the client to a district surgeon for the client to be assessed. You also know that in terms of the Constitution, you as the attorney or counsel for that client are entitled to see him, are entitled to bring a doctor in to see him, and to have that doctor examine him. So think about now the first bail application. Your client suffers from angina. Okay. They must be taken to hospital. Obviously, as defense counsel, you can have your doctor coincidentally also attend the hospital and look at the client and confer with the doctor who's seeing him. Now he has angina. It is much more preferable for your client to spend the 48 hours in a private ward in a hospital as opposed to a prison or a police station cell.
Does the standing order say only if he's sick?
Yes.
If it's confirmed?
Yes, yes. So, now, if you are dealing with your client later on, and he comes up from the cells, and he looks as though he's had the hiding of his life, you say to the magistrate, now you haven't got disclosure of the docket before the first bail application. You say to the magistrate, you must do an inquiry, and this is what you must be looking for, and here is the standing order which provides for it. Now, once again, it is very likely that your client will be released on bail in those circumstances, because the state will start thinking the cost of treating your client as opposed to it be done privately, they will release you on bail. And always remember, in almost every case I've been in, the state's case is weak anyway. Now, why is that important? The strategy that you adopt when you are dealing with the first bail application, is to draft a very long affidavit outlining the constitutional principles, how your client is ill, the assets and liabilities. I get all of that. But you actually record in the first bail affidavit all the standing orders which apply. Now, in the first bail application, so you're basically saying to the magistrate, you need to find these things out. The police know they should have done it. We don't know whether they have or haven't, but you need to find this out. Now, very often, they will not take up the offer. Okay. Then you need to know immediately after the first bail application that you are entitled to disclosure of the docket. My argument would be that you should be entitled to disclosure of the docket even before arrest and enrollment. But that's a harder act to follow. So now the first bail application is over. You stand up immediately and say, I want full disclosure of the docket. Then you are able to bring the application on new fact, premised on the lack of the state's case. And then you are able to take all these medical steps and so on and so forth, which I have suggested. And inter alia, if you spot, like in the one case I was describing, that the complainant is 12 and not a competent witness and so on and so forth, the likelihood is that you would get bail. Now, when I say you would get bail, I'm saying to you, you might have to go to the High Court, but you will get bail in the end, because if you look at the evidence that I have described to you now, I don't know that there are many High Court judges who would refuse to come to your aid. And when you place before the magistrate through both of the bail applications this kind of evidence, but it's very important for everyone to understand that the basis for this is full disclosure, and that is why full disclosure should be given and asked for as soon as possible. Now, I might not have dealt with it, so I'm going to go back. When I looked at Professor Dugard's work, he identified judicial oversight as the crucial issue for disclosure of information, and he indicated the prosecutor. Now, insofar as the prosecutor is concerned, the prosecutor's duty of disclosure, what he should disclose during a trial. I'll use an example of a postponement. When a matter is postponed, the prosecutor stands up and says, may I have the postponement?
For an investigation.
Yes, but he's giving the undertaking to the court. I have a prima facie case, but I need to do this further investigation. Now, that means he has a duty of disclosure. So he should say, this is the standard of the evidence I have. It is a prima facie case. I give you the undertaking. This is what I still have to do. This is why I want a postponement while the accused is still in custody. All right. Now, if you have full disclosure, you are able to say, that is nonsense. And you will find so often affidavits are not deposed. The doctor's 2124 and 8 statement for the postmortem or the doctor's report, the JA did, is not there. You will find that for cell phone evidence, the expert evidence, the spider diagram evidence is not there. You will find that the chain for the exhibits is broken. You will find that the DNA testing is going to happen in 9 months. Okay, so if at all. Now, when you find this out and you thrust it under the nose of the magistrate, he can't grant the postponement because there is no prima facie case. But once again, you will need full disclosure of the entire docket to be in a position to tell the magistrate no, or the judge no. Now, the important issue post-1994 is one of the premier sources of obtaining disclosure is defense counsel. Defense counsel has to know what his client's rights are to disclosure. Because if he doesn't, he or she will not be able to secure the freedom of his client. If it is justified, obviously, a serial killer is a different debate. If he's justified in getting the release of his client, he has to know, I need disclosure. Take a confession, for example. If you have the pocketbook, you have the warning statement, and you have the confession document itself, you are amply provided with information to attack the admissibility of the confession. I'm dealing with a case at the moment where I have a trial within a trial, where the warning statement is bad, the search is bad, the arrest is bad, the pointing out are bad, the securing of cell phone evidence are bad. Now the only way that I'm being able to, and it's been a battle because I still haven't persuaded the magistrate, but the only chance that the only prospect that I have a chance of blocking all that evidence is the full disclosure that I have. And I'm making it extremely difficult for the state witnesses to be able to be credible by the disclosure that I have. So there are important standing orders, and anyone listening to me here will have my address and details, and they would be able to contact me and say, look, I have a trial within a trial on the admissibility of cell phone evidence. What disclosure should I have? I'll be able to tell you. And the point of the matter is you'll be able to block that evidence. I'll give you an example. In the one case I'm dealing with, I have two Chinese people who can only speak Mandarin, who are in a warning statement environment. Okay, so they can't understand any of the languages being spoken to them. So actually, they are on their cell phone, not paying attention. Okay, now the investigation officer leans over and he takes the cell phone. I'll have that. No judge's order, no basis for arrest, can't even warn them properly. So he can't, so now look at what I have, because I have the pocketbook where they weren't warned at all, where the cell phones weren't put in the SAP 13 so that the judge can be asked, can I look on the cell phones? They arrested them for a warrant because they were stealing wastage stones outside Kuruma. So there was no basis for arrest without a warrant. I got that information from the discovery I got. The basis for the arrest was cars were parked askew in the high street. So that is why I'm confident I will win that matter. Now, when you bring the application, you also have to know the provisions of PAJA. Why? Now, when you get to the more sophisticated arms of the South African police, like the Hawks, they know people like me are eventually going to get the docket. So they write in the docket A1 and the date, A2 and the date, A3 and the date, and they give absolutely no explanation as to how the circumstances in which A was taken. And the other trick of the trade there is they do that in the C section of the docket because they know you might get it. Then they have a shadow C section, which is their own diary, okay, where all the information that should be put in the C section is in the diary. Okay, so when you're dealing with the Hawks, be careful with that. In so far as that is concerned, in addition, if you consider that every step taken in an investigation by the South African police is an administrative law act. So when they disclose in the C section, they should be disclosing a rational decision, a reasonable decision, and the reasons for the decision. So now you cross-examine again. I don't have a pocketbook. And the C-section says, took statement A. So tell me, in what circumstances was A1 taken? Can't remember. Now you understand that places in jeopardy the admissibility of that confession because he can't remember. And every document that he's supposed to draft to assist his memory is gone. So when you get a C-section, and possibly the Hawks have drafted it, and it is like that, it is as good for you to get a C-section where it is flawed in that way as it is to get a fully drafted C-section. And I'll give you a quoted case, Minister of Police and another versus Duplessis, 2014-1 SACR 217 SCA paragraph 34, where the C-section is quoted in the following terms. This is the prosecutor, and I'm coming to the prosecutor in a moment. Hierdie saak is met alle respect nie behoorlik ondersoek nie. That's the gold you get in the C-section. Now, what he's really saying is this matter shouldn't be on the roll. Forget about bail, 174 discharge, trial within a trial. It shouldn't be on the roll. Now, that's not the first time I've seen something like that. And so it becomes very, very useful, absolutely essential to get full disclosure of the docket. Now, the prosecutor has regulation. Now, when I speak of the Hawks, the South African police and prosecutors, there mustn't be, I've already said to you that if they do it properly, they're going to get much more convictions. So the law around disclosure is not defense-orientated only. If you have full disclosure, you will simply raise the standard of investigation that the police do because they know you're going to get disclosure of how they did it. So it's a win-win all round. But the point of the matter is the prosecutor has similar regulations. Now when you get copies of the regulations, you're going to see that they are really quite good. Not quite good, very good. In the way, the care with which they've been drafted and with the practical nature of how they've been drafted. So there are a lot of good people in the State Departments is what I'm driving at. The second thing is the prosecutorial regulations are very important. Now you've got a case like some of the cases I've outlined where you say, where I've told you the flaws in the state's case. And now you argue, the prosecutor is asking for a postponement. Do you know that the regulations for prosecution say a prosecutor must review his or her decision to enroll a matter, that a prosecutor can stop a matter, and that, so now you're arguing the postponement. You're arguing against the postponement. And you take out the regulation and you say, Your Worship, my learned friend should be careful. The Director of Public Prosecutions, via his powers to regulate, a Minister of Justice, by his powers to regulate the Director of Public Prosecutions, says the following in his regulations. A prosecutor, where it is appropriate, should review his decision or her decision to enroll a matter or continue a matter. Now, the effect that has on the prosecution, I have found, is dollar signs coming to his or her eyes. How much are we going to pay for this mistake? Okay. So when you are trying to say to reason with the prosecutor, look, you've got no case, why are we here? It helps to have the regulations. Now the regulations and the standing orders also say, for example, that the prosecutor and the police are a team, where, for example, they oppose bail. In the A, B, or C sections of the docket, and it's usually in the C section, the investigation officer must declare in detail why he opposes bail, and if the prosecutor doesn't agree with him or her, the prosecutor must sign for it. Okay. Now, when you have that information in your hands, think about how powerful it is when that postponement is being asked for. Because the regulations and the standing orders say that, okay, and it's not there. So, and your worship, you should be inquiring about all of this, and it's not there. So how is this postponement justified? Now, the reason why PARJA is important, as I said before, is every decision but enrollment is an administrative law decision. So the administrative law on the type of reasons that have to be provided for every move must be in the A, B, and C sections of the docket, and it's usually in the C section. Now, if it's there, it's helpful because it's usually wrong, and if it isn't there, it should be there, and so it's helpful. All right. Now, insofar as enrollment is concerned, PARJA specifically says that the decision about enrollment stopping or stopping a criminal trial is not an administrative law decision. But some of you who do administrative law would know that the principle of legality has grown up alongside PARJA. And some of the writers in some of the cases say that there's really no difference. PARJA has time dates, time periods, and legality, by and large, has exactly the same principles without time periods. And it's very, very important that when you tackle in a bail application, for example, that the state doesn't have a prima facie case, that you can still attack the decision to enroll the matter on the premise that it contravenes the principles of legality. Now, the last thing there's two last things that I have to deal with. The one issue is onus. Now I get again back to the security state provisions of, for example, the Internal Security Act and so on and so forth. Prior to 1994, if you wanted disclosure, the onus was on you to explain why you wanted that. Now remember, you had no documents, so good luck with that onus, because you had nothing to you can't see it, so you can't justify having it. Okay. After 1994 and with the Chabalala decision, the onus is no longer the prosecution's as to whether you should have that information or not. The onus is upon the onus is now upon the state to say why you shouldn't have it. And there are acceptable categories that they can only raise. For example, international policing secrets, disclosure of an informer, secret methods of investigation, and there are two others that escape me at the moment, but they are a closed list, and those are the circumstances in which they have to justify to the court why disclosure should not be granted. Okay. If I might break off and deal with informers for a moment, I can't tell you how many police cases that you're going to have which have the following statement under oath by the investigation officer. I got information from an informer, and therefore I arrested the accused. Okay. You need to know that you are entitled to the informer's statement. What has to be in order to protect the identity of the informer. You have scratched out all his personal details, his address, and so on and so forth. And in addition, there is a docket on each informer. This would be a formal informer, where his track record of how well he has informed is recorded in that docket. So if he's lied in the past, you can find out, is he a reliable informer or not? Now, that is a hidden fact in state investigation. So you get a statement, an informant told me and therefore I arrested the accused, in short. Okay. Now you are supposed to, as defense counsel, just accept that the informer gave the policeman all the reasons for reasonable prospects of success, so that reasonable suspicion, so that he could justify the arrest. You just have to accept it, like magic. The informer said, and you don't know that you're entitled to that informer statement. You're going to get huge resistance from the bench and from the state representatives in giving you that statement. Now, obviously, if you make a fuss and they don't give it to you, you then argue, well, the lack of evidence counts against them, and therefore your client should be discharged. If you get the evidence, you will find that the informer is unreliable. But you also stop the investigation technique of the South African police justifying their conduct by, it's like a blank check. The informer says, so we're entitled to do this. In fact, in many instances, there was never an informer.
Is there a standing order regarding informers?
Yes. Yes. And in fact, in many instances, there was no informer. It is known that generally defense counsel do not know that they're entitled to the information I've said. So they know you're not going to ask for it. So they say an informer said, and they justify this conduct by the informer said, and no one looks behind that evidence. Okay. Now, the last thing is I wish to talk to you about is PIA itself. Now, I have to confess that I was given, and I have already, so I shouldn't do it too often, that in the Kerr-Phillips matter, I got a high. Okay. Now, obviously, counsel always said they were never wrong and the judge was wrong, so I am going to say that, but I'm going to ask you to listen to how I say it before you go any further. All right. What concerned the learned judge in that matter was that PIA had come out, and he was concerned with the principle of subrogation. So he said to me, don't try going round the act with me. You didn't apply in PIA, so go home. Okay. Now, as I see the development of the law since then, and anyone who applies for the docket might be faced with this, definitely in the High Court, is Section 7 of PIA says, basically, when a matter is started in a criminal court or a civil court, the rules, once it is started, that previously applied or apply to civil and criminal procedure apply, and PIA does not apply. Okay. So now, in addition, you have the 1996 constitutional provision, I think it's section 32, which says you're entitled to information in the hands of the state. So you would use that as an interpretive device to get round PIA. Now, the way I try and get round PIA, and I haven't tested this argument, but I hope to do so, is what about the law from 1994 to 2001, before PIA came out? All the principles that I've discussed throughout my address were already in case law prior to 2001 when PIA came out. So would it not be correct that if Section 7 applies, that PIA itself is kicked out by Section 7, and the constitutional principles which I have referred to earlier apply? Because that law was already in existence. Okay, that's the first thing. The second thing that the learned judge said in that matter is you can use a subpoena's decus tucum to get the information in the trial. And the subsequent authorities say in any event, they're not sure PIA would apply to the disclosure of the docket anyway. And there's a long, convoluted argument for that purpose, which I'm not going to go into now. But think about it. You use the subpoenas ducus tecum, they have to bring the B and C section, and the arguments that I've raised will be raised anyway. It will just be under a different pathway. So when you are faced with, you should have come under PIA, I suggest you would argue that. In addition, and I think the learned judge was right and I was wrong, when you go against a private institution, you have to go via PIA. So now you have to decide in your, now this has happened since that judgment. There are cases which say the state cannot redefine itself by giving institutional tags to people who have their information. Okay, so when the state prepare their brief, to use the example I had in Kerr-Phillips' case, the teddy bear clinic is a state witness. So they can't say, there are cases which say this, they can't say, well, we'll call that the teddy bear clinic evidence, so it's not in the docket. So you can't have it. Because the Constitution says you're entitled to evidence in the state's hands. There's no qualification. All right. If it doesn't say that, if you lose like I did in Kerr-Phillips, you're going to have to bring the subpoena ducus tecum route. Why that is a disadvantage is the teddy bear clinic in that case raises the privacy of the child. And section 28. Now, the point of the matter then is, I think, well then you say to the judge, well that's all very interesting. You cannot assess the competence of the child because it's private information which you can't see. So you can't decide on the competence of the child because you've blocked the evidence. So that's fine. So you can't assess the competence of the child, therefore you can't admit the evidence. I'm quite happy with that because then there's nothing before you. Now, that's how I would argue it. But there could be an accusation that that's a very sexy argument. And you do find definitely with children cases that the bench will lean over backwards to assist the child, and I'm not sure if I was a presiding officer I wouldn't do the same. What that really means is you need to know the exceptions, but you need to know the overall issue that you need to get full disclosure to be able to fight those arguments. All right, so lastly, I'm going to briefly refer to why you would need the C-section for watershed moments in a trial. You need the warning statement and the pocketbook entries for an admission, a confession, a pointing out, a trial within a trial relating to the admissibility of hearsay evidence, a trial within a trial relating to the admissibility of cell phone evidence. I think I've got them, and a trial within a trial relating to the competence of a child to testify. Right. You would need the NGO evidence, if I can call it that, for a child when you're fighting the testimony of a child as a competent witness. And you need to be very careful with that, because this again, and it happened in Kerr-Phillips, is the game that is played by the state. They call a social worker. The social worker in Kerr-Phillips was actually highly qualified. Okay. She's not a psychologist. She can't do psychometric testing. She can't give a conclusion on the mental state of the child. So all the social worker can testify to, and that's the purpose of 170A, is does the child need an intermediary or not? And generally, as defense counsel, you would have empathy for any child appearing in a court and the stress that that child would have. So you would readily concede without contest that the intermediary should be there. I mean, I think it would be foolish to do otherwise. But the point of the matter is that social worker cannot testify as to the competence of the child. Only a psychologist can. And if you read the relevant acts, you will see that in fact a social worker commits a crime, in my humble submission, when they do that. All right. So the child has to be assessed by a psychologist. If the child was interviewed by a social worker, you want disclosure of all of that, the circumstances, the notes, and so on and so forth. Because what often happens is the social worker suggests to the child what is better evidence to give. Now, if that happens, and obviously I can't speak for every social worker, if that happens, that evidence is inadmissible anyway because it's contaminated. So you would need that disclosure. All right. So you would need it for child evidence. In a murder, you would need the C-section for the chain evidence of the body from the scene to the post-mortem tape. All of that detail and flaws in that detail will be dealt with in the C-section of the docket. The hearsay evidence is a problem. There is case authority against what I'm about to argue. But what normally happens when the state leads hearsay evidence, they ask for the evidence to be provisionally admitted. Now, we all know what that means. It's provisionally admitted and then it wanders into the mist as to whether it's admissible or not. No one deals with it. Then, right at the end, you get a judgment. The presiding officer realizes, well, what am I going to do with this hearsay evidence? So he finds corroborating evidence for the hearsay evidence, and your client is convicted, I think, incorrectly. All right. So you often find in the C section where there is hearsay evidence, the prosecution say, for the hearsay evidence, I want the following corroboration: 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, because they know it's hearsay evidence. All right. Never happens. So when you get the C section with that indication of what should be done to corroborate the hearsay evidence, and it never happens, you are able to argue in the matter. You can never look at this evidence because out of my learned friend's mouth, it's inadmissible. All right. Obviously, you need to know also from the regulations of the prosecutorial regulations that a prosecutor should, and there's case authority for this as well, should, where, for example, there's any evidence that admissibility will be an issue, they should call for a trial within a trial. They often don't, and the bench often lets them get away with it. But they should say, my lord, I have hearsay evidence. I'm going to suggest that we have a trial within a trial, and we deal with the admissibility of the evidence before you hear the merits. Because they know a good prosecutor would know the consequences of poisoning the well with hearsay evidence which hasn't been supported by corroborating evidence. Now,
I wanted to ask you, sorry.
Go ahead.
On the, the testimony by the social worker, would you object to them speaking out of their expertise?
Well, the way I handle that is I say, I'm not contesting the intermediary, you don't have to call the social worker.
Oh, okay. done.
then the social worker is finding that the client is competent or not, or the child is competent or not, is not led in evidence, then the prosecution would go, oh my goodness, I actually needed the social worker. Then you start with the trial, and then you raise the objection. Also, what will happen in those cases more than likely is the bench will ask, now how old are you? When you were a girl guide, did you know the difference between right and wrong? What did they tell you about right and wrong? They told me I must tell the truth, etc., etc., etc. If I told you my shirt was blue when it's actually white, would you be telling a lie? Now, the case authority in that regard is that does not test the competency of the child, and you need a psychologist's intervention to know. Because the presiding officer, by asking those questions, cannot fathom whether the child is competent or not. Okay.
Thank you.
All right, now, questions.
Thank you so much. So our session has gone on a bit longer than we anticipated. If there are a few questions, we can deal with them. But if you feel that the session has been long enough and you would like to stand over your questions, you can do so. But if there are burning questions that you'd like to pose to Graham, I think let's deal with them now. Graham, do you still have time?
I have time for you, absolutely.
How?
Sorry. Yes.
Thanks, but Graham, I just wanted to find out at what stage do you object to a delay? I know a delay is a delay and it's unconstitutional, etc. But when you keep being given reasons and you don't get to address the court about the unconstitutionality and unfairness of the delay, how do you go about it?
Okay. Can I talk to you about my experience of court policy in that regard? In the High Court and in the magistrates' courts, generally the presiding officer practically does flip-flacks to prevent you succeeding with an unreasonable delay application. Okay. So what I do is you start the game as soon as possible. Now, then you might bring it once, you might bring it twice, you might bring it 3 times. So when your client gives you an instruction to take the point, you tell them, this is not going to be an easy peasy thing. I'm going to bring the application once, twice, maybe even up to 5 times. But the point of the matter is, if you think, I should have brought it, and you don't, you're never laying a basis for the next attempt. Because I find if you wait a long time and bring it for the first time, then you still have to bring it 3 further times after that, even though the delay has been very long. I mean, there is quite a host of authority, like Brum and those cases, which deal with unreasonable delay. In my practice, though, I find on any of the constitutional points that you raise, it's like a fashion. It's not that fashionable anymore. So you have to work much harder with an unreasonable delay application. I would combine it with, look at what the state has proved. They have proved this, they have proved, not just the delay itself. Okay. Now, I have been in one, and I'm trying, and I see Stephen May is smiling, I'm trying to bring an unreasonable delay application now. And it was, I'll give you a soupçon of what you're going to face by talking about the facts of the case. Okay. He's been in custody for 219 days. Okay. No, sorry. He's been in custody for a long time. I'm mixing cases. All right. Now, I am applying for the A, B, and C section of the docket. So the magistrate turns the application for the docket. Now, because she's bullying counsel not to just collapse, which is the practice of many magistrates. Okay. So then she starts to itemize all the things that my predecessors, and the case has been on the roll for a long time, my predecessors have done wrong in a trial. This attorney did this, caused this delay. This attorney caused this delay, so on and so on and so forth. Now, I'm applying for the docket. So I said to her, Your Worship, you're not giving me an opportunity to respond to you on all these allegations of delay you're making that the defense have done. But please understand, I'm quite happy to have this unreasonable application. Let's start. Because during the application, I will justify why I should get the docket, so let's begin. And immediately that I did that, she gave me the docket. Effectively, she's given me the docket. So, with an unreasonable delay application, you're going to have problems. Now, insofar as I litigate is concerned, I would bring an unreasonable delay application because if you pressurize the bench and the state from every single corner, okay, in the end, they collapse. It's a game of brinkmanship. But if you're going to bring the unreasonable delay, you would first ask for the docket because you will find a gold mine of information for the purposes of the unreasonable delay, because you will be able to see the really terse comments by the prosecutor. This is the third month that you haven't done this investigation. Then you are able to argue, my Lord or Your Worship, this delay is admitted by the state, it's common cause. So you, exercising your constitutional mandate to see that my client has a fair trial, have to do something. And obviously if your client is in custody, which is often the situation, there's a case, Joseph, which says the following: you shouldn't strike the matter. You should be mentally agile, talking to the bench. Release him on bail. Let justice prevail, but release him on bail because of the delay. Now, if your client's in custody and he's released on bail, you already have a huge win in my view. So definitely if there's a long delay and your client is in custody, you need to ask disclosure of the docket because in the C section you will find a huge amount of information for the purposes of the unreasonable delay application. But you're going to have trouble. Doesn't mean you shouldn't do it, but you're going to have trouble. And I have to tell you, now that we have COVID, the ability of the bench and the prosecution to finesse you in bringing such an application is huge, because you don't get past the C of COVID before the postponement is granted. Yes.
Earlier on you mentioned that if your client is ill and they're to be arrested, they should be seen by a district surgeon. Now, would that be, if I got that correctly,
Yes.
would that be an instantaneous thing upon arrest, or will they go to the cells and then be sent to a provincial hospital to be?
Well done, good question. If a policeman in the 48 hours before the accused is brought to court realizes that the client is ill of their own, without your intervention, they should send the accused to the district surgeon. Usually it is that he's been assaulted.
And what if they were arrested ill? What if they were ill upon arrest?
Now remember, you as counsel are there more than likely when they're arrested. Okay. So now, how do you bring about that he sees a doctor? Okay. You write letters to the station commander. My client is ill. This is what you should be doing. You're not doing it. Please give me by this hour an indication whether you're going to do it. Otherwise, I'm going to bring an urgent application. Then you bring the urgent application. Can I tease you? It's really funny. I had a really old Italian guy as a client. He did suffer from angina. I did follow the procedure that I've given to you. So he gets bail. Now he comes up from the cells like Getafix with his walking stick, bent over it. He gets bail. He throws the walking stick across the courtroom to his wife. Maria, let's go home.
Stuff out of the movies.
Wow.
But he did have angina. And the procedure that's followed there is there are hospitals that have closed wards. The Rosebank Hospital here, they took him under police guard until the bail application. And then he was treated, and then the doctor gave the evidence, and the evidence was led in the bail application, and he was released.
Whose expense is it? Would it be a private expense or the state would have to take care of it?
Okay, good question again. Because obviously, if the state sent them, it's at state expense. And obviously it would depend on the wealth of your client. And obviously he would prefer to be in a hospital like the Rosebank rather than a police cell.
Right.
But the point of the matter then is, if you cannot, let me rephrase it. When you are securing the evidence, remember the Constitution says that he's entitled to access to his doctor in the 48 hours. So at the very least, you take the doctor to him and he does the analysis so that when you go to court at the end of the 48 hours, you have the evidence and then he should be released on bail with obviously stringent conditions. I mean, we are lawyers, we do believe in justice, but it would be stringent conditions which you would then agree to. But yes, generally, the state obstructs you because they don't want to pay.
Any other further questions? Right, Graham, thank you so much for your
It was a
time.
pleasure.
And again, as I indicated earlier when we started, this is an initiative. Look, this is very trial and error for us. So initially, we will make mistakes, we will have difficulty, and the longer we do this, the better we'll become at it. So bear with us. If you've been here for the first or the second time, you must come and see how well we'll do on the 8th time. So, Prof, I'm very happy that you're here and all of those who attended. We're going to have another session on Thursday next week, a further informative session. We'll advise you in good time who the speaker will be and what the topic will be about. But for now, Graham, thank you so much. We will make a copy of the recording available to those who unfortunately lost signal. We had a power failure, and we'll post it on YouTube, and from then you can access the information. Thank you so much.
Thank you.
Join us for some refreshments afterwards.